Next case is Dorko versus Dorko. This is a mini oral argument on the application. You each have 15 minutes. You may reserve time if you wish.
Thank you.
Welcome.
Good morning. May it please the court. My name is Jeff Schroder. I represent the appellant plaintiff, Richard Dorko. I would like to reserve 2 minutes of my time for rebuttal, please. I think that the court is called on to sort of weigh two things here. One is what the law is, and I think that we look to interpretation of the statutory language to do that, and then the other prong is what the law ought to be, and so why should we have a statute of limitations for the entry of a quadro? So when we look at statutory interpretation, there's two facets of this case that applies to. First is the waiver of the statute of limitations defense that's been argued by opposing counsel, and opposing counsel argues that because Rick Dorko did not raise the statute of limitations in his objection to a quadro that was entered under the 7-day rule, that he somehow waived that. But if we look at the language of the court rule, we'll see that pleadings are specifically defined in the court rule. And those are things like the complaint, the answer, a cross claim, that kind of thing. It does not state that pleadings include an objection to a 7-day order. And so I think that if opposing counsel is going to say that, well, Rick Dorko gave up his statute of limitations defense because he didn't assert it. Truthfully, he didn't know to assert it because he was representing himself at that point. But, opposing counsel should have to point to something more than the court rule that says that you waive it if you don't mention it in your first response of pleading, especially where pleadings are defined as things not involving this case. Also, statutory interpretation in terms of accrual and whether or not a person has a right when they're getting divorced that's accrued at the time they're divorced, or whether that only accrues many years later, perhaps when one of the parties retires. And I think that if you look at the statutes involved, accrual is used when the statutes direct a trial court to divide a person's retirement benefits, and the word accrual is used. The 552.18 specifically says that a court is required to divide the accrued retirement benefits, which makes sense because a court can only divide what's within the marital estate. A court cannot divide something that's outside of the marital estate, and so when a court is doing that property division in a divorce case, the court has to get their arms around, well, what retirement benefits are we dividing here?
Counsel, how would I know when that benefit becomes available if I'm on the opposite side? Like, how am I supposed to keep track of that?
Well, my first answer is you don't have to. The trial court is there to divide the benefits and to assign property interests to the parties. And then after that is accomplished, then quadros are entered. And then when a person retires, it's up to the plan administrator and to the parties to seek their benefits from the plan administrator. That doesn't have any involvement with the Michigan courts. That's federal litigation that happens. So when a trial court divides the retirement benefits and then quadros enter, and then those quadros are approved, at that point, the Michigan state courts are removed from that litigation. And that goes forward in the federal court, and that's really a lawsuit between the parties and the plan administrator. So we're not called on to determine when somebody is going to get their benefits in a family law case in Michigan. We're called on to divide who gets what. And I think that because it's that way, it makes sense that we have a statute of limitations because we need the litigants and the parties and the attorneys to understand that we're dividing rights that it's a present interest property right that's being divided in the family court to receive future benefits. So, so then what happens when we don't have a statute of limitations, when it's just out there for the Michigan courts to perhaps have jurisdiction over this kind of property division 10, 20, 30 years later, when somebody retires and actually receives the money that they're entitled to? I don't think that's the intent of the legislature, to have our Michigan courts involved in that kind of litigation many years later. Again, that's federal litigation that doesn't involve necessarily arguments between the litigants or the parties and the plan administrators. So that's one thing that can happen. And the other thing that can happen when you don't have a statute of limitations is what happens in this case. Somebody delays more than 10 years, and Rick Dorko is faced with either can't retire, or if he does retire, he's told, what options he has to select upon his retirement. And that he's told that by the plan administrator, and because the other side hasn't preserved their rights with the quadro and hasn't done what they should have done with the quadro, now he's receiving benefits that the plan administrator is telling him that he has to do it this way.
Weren't both parties required to file the quadro?
I don't believe so. I don't remember, to be honest with you. I know that we're only dealing with Sherry Dorko's portion of Richard Dorko's retirement. And I haven't really involved myself in determining whether Richard Dorko got any of Sherry Dorko's retirement. I don't remember that that's the case.
No, my question is whether the divorce judgment required splitting the pension 50-50.
Correct.
And whether both parties were required to file the quadro.
Typically, no. The party receiving the benefits, it's their job to retain an attorney to draft the quadros and have those entered at the trial court and then later approved at the plan administrator. So usually the party receiving the benefit drafts the quadro, although there are times where attorneys and parties will agree that the other side will draft quadros, and that really has to do with who's in the better position to pay for it and that kind of thing. But no, this case just involves one set of qualified domestic relations orders that really wasn't undertaken until Sherry Dorko realized that Rick had retired, and it was more than 10 years later. The other thing that we're looking at is, where does the trial court even look to get their authority to enter a quadro at all? The only thing that gives the trial court the authority to do that is the judgment of divorce. And when that judgment of divorce expires under the statute of limitations, how can the court...
Does a judgment of divorce expire?
Well, a statute of limitations renders it unenforceable.
So if there's custody provisions, those just get dissolved or go into the ether? I mean,
No, and the people remain divorced too.
right.
But that does not mean that property division continues in the same way. We've got case law that shows that this 10-year statute of limitations applicable to the judgment does apply to divorce cases and to the property.
This isn't a money judgment in that sense, is it? It doesn't. The divorce judgment doesn't say defendant shall pay to plaintiff, $100,000 on this day. That's not the kind of judgment we're talking about here, is it?
Correct. It also, we're not,
I mean, so
but it is property division.
Why does it make sense to think about the statute of limitations where the obligation itself is something that's could be long into the future? The obligation to pay, depending on the particular plan and the type of plan and the age of the parties and all these other factors. That's why this is so complicated, right?
Sure.
So this is not this moment in time obligation. This is, you're agreeing to split the plan whenever it becomes due, and whatever amounts the plan administrator determines will effectuate the terms of the divorce judgment, correct?
Well, I don't agree with that, and I think that's the essence of this case. What the family law courts, the Michigan courts, are doing is dividing a person's property interest that they own at the time that they're getting divorced. So that is a discrete moment in time. And
So does the plan administrator segregate the accounts when they receive the quadro order?
yes, typically,
They create two separate accounts.
usually, yes. They don't have to. I mean, it depends on whether a person has already retired. It depends on whether it's a separate action or a
That
joint
obligation might or might not be paid within 10 years, right? We have no way, this could be due 15 years after the,
Correct. But the property interest that the family law court is dividing is known at the time that the people are getting divorced and the
but it
judgment
can't
is
be,
entering.
but it can't be enforced. It can't be collected, right? You can't send a garnishment to the plan administrator, can you?
Correct. But again, litigation about enforcing a person's property interests that they hold by virtue of the judgment of divorce is federal litigation against a plan administrator. It's not litigation in the family law court in Michigan.
But I'm just trying to think of it in terms of why we should think of this case as falling under MCL 600.5809 with respect to a 10-year statute of limitations, when a lot of other parts of the divorce judgment you've just conceded, I think, don't fit under this statute. But you want this part of it to fit under the statute.
Because it's property division in the same way that a person's house and who gets the television and who gets the Chinette set. And
Well, but it doesn't say that. It doesn't say property. It says enforce a non-contractual money obligation. That's a money judgment, right? That's what we think of as a money judgment. You know, your credit card, you don't pay your credit card company, they get a judgment against you. They have 10 years to enforce it, or they show up in court, which they always do, and renew the judgment. They pay some fee and renew it, right?
it's my belief that that would be a contractual money obligation, and we're talking about non-contractual money obligations. So the court in Peabody v. DeMaglio stated that the 10-year
So
statute...
contractual or non-contractual, I mean, it's a good, fair point, but it's still a money obligation.
It's property, yes. The property happens to be money, but it could very well be, presume somebody had an interest to receive a TV in 10 years. I mean, you can divide that present interest in receipt of a future property. And that's all the family law courts can do, really, right? I mean, we can't divide things that are unknown or that aren't within the marital estate. And our statutes direct the courts to divide things that have accrued. So, with that, thank you very much, and I'll reserve the rest of my time for rebuttal.
Thank you.
Good morning. May it please the court, George Perrett here on behalf of the appellee in this matter, Sherry Sue Dorko. We're asked here today in regard to the imposition or prospective imposition of a statute of limitations in relation to the submission of a qualified domestic relations order pursuant to 29 U.S.C. 1144b7, which would accept it from the preemptive provisions of ERISA. Generally stated, the issues of statute of limitations in this court, we talk about them in the case of Stephen versus Dixon, 449 Mich. 531, a 1995 decision of this court, indicating that statute of limitations are procedural devices intended to promote judicial economy and protect the rights of defendants by precluding litigation on stale claims. So really what this case boils down to is, what's the claim? The claim in this matter is a claim against an ERISA-qualified pension plan. The claim is not a claim against the appellant. That has already been determined pursuant to the judgment of divorce. At this point in time, the only way for that claim to be enforced is for the submission of a qualified domestic relations order. Getting to Justice Clement's point, the judgment is silent as to who is to submit the qualified domestic relations order in this matter. It's an obligation of both parties. When we talk about typical practices in family law courts, well, typical practices these days, indicate that in a judgment of divorce, if in fact a particular individual is to submit the qualified domestic relation order, typically we have that identified within the judgment of divorce. As a general proposition, we know that courts speak through their orders. In this matter, the court spoke through its order. Judge Gorsalis ordered that the parties would submit the qualified domestic relations order. So there's a question is about whether, in fact, my client was delinquent in the submission of the qualified domestic relations order, or both parties were delinquent in the submission of the qualified domestic relations order. But irrespective of whether they were delinquent, it's not barred by a statute of limitations. The claim in this matter is not a claim against this appellant. It is a claim against the pension plan. The Jogan decision, which is one aspect of the application questions that we've been asked to respond to this court about, correctly determined that the submission of the qualified domestic relations order is a mere ministerial act in support of and in compliance of the judgment of divorce that has been entered by the trial court. It is nothing more, nothing less, as that court indicated. Now, the dissent in Jogan makes an analysis of the three disparate views on how this issue could be approached, including the issues set forth in the Duhamel case in New York, and it talks about the Lawrence case in Kansas, and it talks about the case in Indiana, the Jordan case. And of course, the majority followed the Jordan opinion from Tennessee, in which the Jordan case makes the point and relies upon the Ninth Circuit decision in Gendro versus Gendro that specifically states that in a declaratory judgment regarding the dischargeability of an ex-wife's pension interest in that matter, the Ninth Circuit held that the alternate payee ex-wife had a right to submit the QDRO that could not be discharged. The gravamen of that decision is that it was her interest that was being asserted. If in fact the QDRO never entered in this matter or any other case, under the judgment of divorce, that interest doesn't get revested in the appellant. It just simply isn't acted upon by the plan administrator. Getting to Justice Markman's question, I believe it's Justice Markman's question about the division of the asset. Well, it depends, I suppose, in part whether it's a defined contribution plan or defined benefit plan. The defined contribution plan, the quadro, would be established in two separate accounts. But irrespective of that, it's the interest of the alternate payee that's at play here. It's not the interest of the appellant. The appellant's interest has been assigned. The appellant's interest is gone. It doesn't revest in the appellant. It's one of those propositions where if my client wants to get the benefit of this pension, she ought to submit the qualified domestic relations order. But if she doesn't, it's no harm, no foul to this particular appellant. And if that's the case, then the very basic premise of a statute of limitations isn't being fulfilled.
Why isn't it a harm, though?
There is no harm.
Well,
where's the harm?
Isn't it a division of the assets?
No, because the division of the asset, well, the harm is to my client if she doesn't ostensibly, if we want to call it, perfect her interest in the qualified pension plan. But it's no harm to the appellant. He's not getting any less than he was entitled to under terms of the judgment of divorce. In fact,
But he's still getting he's getting, I mean, practicality, he's getting less money.
No, he's getting less money, but he's getting less money not because of the lack of entry of the qualified domestic relations order. He's getting less money because that's what the state court determined was an equitable division of the marital estate. So he's not entitled to anything more than that.
So your client had the right, the day after the entry of judgment was entered, to obtain the quadro. She had the right or the ability to do it 7 years, 11 years, and 3 days, 20 years. I mean, the risk was on her.
Correct.
That that right to the benefit could be jeopardized in that meantime, but there is no limit on when she could have sought to enforce that, which to me asks the question, why would anyone wait?
Why do people wait? They wait because they're not attentive to it and they don't do it.
There's no suggestion that because it was at least closer in time to when the benefit became payable. Is there some evidence in the record that suggested that that's when she thought the
No.
obligation to file the quadro perfected?
No, it may have triggered her perception in her mind about it, but
But she
there's not-
could have the day after.
Well, it typically, and as a matter of practice, we would wait out the appeal period on the, before we
Well, sure.
submit a quadro.
Okay.
But with respect to the division of the marital estate, that's set at the time of the judgment of divorce. And before I forget, I jotted down a few things in counsel's argument. First of all, the notion of waiver of statute of limitations and it not being applicable to an objection, with due respect to counsel, that's simply not the case. It's a first responsive pleading. Not only did that not occur in the first responsive pleading, it didn't occur in the second responsive pleading. It didn't occur until the third responsive pleading. And the case law in this state is clear. That constitutes a waiver. By example, we talked about the bulk petroleum case. It clearly applied to motions in that case. It applied to summary disposition motion in that case. The Palenkas case talks about the fact that it's broad. This is a broad application of the waiver. So we had no objection the first time based on statute of limitations. We have no objection the second time based on statute of limitations, and it wasn't until the third time. The irony of this, of course, is that we're here about statute of limitations concerning the timeliness of my client's submission of the qualified domestic relations order, yet the appellant would have this court not insist upon the timeliness of its objection on that basis under the Michigan court rules. So we've got a little incongruity here. The second point raised by counsel about the accrual, we're talking about apples and oranges. The accrual of an interest during a marriage is defined and is set or liquidated at the end of a marriage, at the entry of a judgment of divorce. That's completely separate from the accrual that triggers a statute of limitations. We're talking about a claim accrual at that point in time. And again, we get back to the point of what's the claim? Well, the claim in this matter, this is a third point that was asked in your application directive to us, was when does a claim accrue? Well, a claim accrues for an ERISA qualified plan when the qualified domestic relations order is submitted, entered by the trial court, and approved by the plan administrator. Why is that? Because the claim doesn't lie against the ex-spouse. The claim lies against the plan administrator, against the plan. The interest has been assigned at that point. It is a distinct interest, in essence, not perfected, but within the province and control of the alternate payee, the ex-spouse. So that's the accrual that triggers the statute of limitations.
Do you agree that entry of the proposed quadro is a ministerial task?
Yes, I do. It is. But with due respect to the Jogan decision, it didn't, and by the way, I don't know whether it's Jogan, I'm not sure, but the predicate for it, I agree with it, and it relied on the Jordan kind of analysis of being a ministerial act. It is. It's being done in compliance with the terms of an order. The dissent in Jogan, written by Judge Danson, talked about the fact that it was the right to entry which was at issue. Well, it's not a right to enter. There's no discretion. It was, if you want to perfect this interest, here's what you have to do. You have to submit the quadro. It was ordered. The definition of ministerial task is that the actor lacks independent judgment or discretion. It is a ministerial act. The dissent, unfortunately, I think, confuses that concept. In fact, there's a later provision at the point in time in her opinion in which she talks about the fact that there was no discretion and no judgment could be exercised. Well, yeah, that's right. That's why it's a ministerial act. She also confuses the point about the fact that the judge has the discretion to enter or not enter the qualified domestic relations order. That's not the discretion we're talking about. That's not the judgment we're talking about.
Under Jogan, is a ministerial act and an action, are they binary? Is it either an action or a ministerial act? Or can it be something more than a ministerial act but not an action under the statute of limitation?
No, it's a ministerial act, period. It's not binary. It's It is.
If it's something more than a ministerial act, then is it necessarily an action under the statute as it's written?
No, I don't think it's an action in the context of the statute of limitations application. No, I think it is, the submission is a ministerial act. It's already been ordered. It's complying with the existing order. It's not an independent action. It's not something, and as I've said now, we're probably going 3 times, it's not an action against the appellant. It's an action against the plan, if it's an action at all. And that act is not prohibited. In fact, it's compliant. It's what's directed by the court, and as such, it's a ministerial act. So the rub on all of this, and it's kind of been lost in all this, this is a risk of quality. The final point I guess I'd like to make is that, we're talking about other assets. Okay, well, you don't have to have a quadro entered for the transfer of a piece of property. That's an action to enforce the judgment. You don't have to transfer a title of a car or to transfer a different asset or divide the personal property. So, a spouse doesn't give over what she's supposed to give over, or he doesn't give over what he's supposed to give over. Well, that's fine and dandy, and you may have to bring some action to compel compliance with the judgment of divorce at that point in time. But an ERISA qualified plan is a qualitatively distinct asset. It is preempted by federal law. It is dealt with. It is a creation of federal law. And as such, there are certain specific and special rules that apply to it, which first and foremost include the issuance of a quadro by the trial court that is then submitted to the plan administrator for approval. So this isn't the same as the transfer of a piece of property or real estate, or transfer of a car, or transfer or division of personal property. This is a qualitatively different asset.
If we were to adopt your position on when accrual begins, would your client have been able to wait 10 additional years? So 10 years after the plaintiff was receiving his pension, and then file the quadro, and then what happens from that point forward? Do they go back and look at the entire pension? Is it just going forward? I mean, it creates, I think, some uncertainty.
I'm not sure it creates uncertainty. The federal courts are pretty clear about the fact that the plan administrator operates pursuant to a QDRO. So if there is no QDRO in place, then the plan administrator is obligated to follow the terms of the plan, which is to pay the payee. The alternate payee isn't even among the prospective recipients at that point in time. Again, it's a little bit of the whole snooze you lose kind of thing, and that is, if you don't submit the QDRO, you don't get paid. And if in fact there were an argument akin to something to the effect of, well, he or she was paid and I was supposed to get that money, but I didn't submit my QDRO and I want him to repay me that money, then I suppose there's an argument at the trial court level about either not a statute of limitations argument, maybe a laches argument that talks about the fact that equitably it's not appropriate. You sat on your rights and you didn't exercise them in a way that would allow or permit recovery at this point in time because you didn't take action to do that. But getting to the basic point, there is nothing, and this gets to the Directors Guild versus Tice decision that's cited in my brief. There's no conceptual reason that a QDRO has to be submitted before a planned participant is retiring. In fact, it can be many years later, and given if somebody were to retire, I see my time's up.
Yeah, thank you, counsel.
Thank you.
So just in terms of ministerial tasks, I agree with the family law bar in their assertion in their amicus brief that it's not just a ministerial task because the trial court judge is called on to make decisions about whether the quadro that has been presented conforms with the judgment that has been signed. So when the trial court judge is called on to make decisions like that, it's not just a ministerial task. It's
So
not just.
if I agree with you that it's something more than a ministerial task, I still have a hard time when I look at MCL 600.5809, whether this is an action as that is used in the statute. when I look at Chapter 58 of the Revised Judicature Act, which all talks about limitation periods, they never talk about civil actions. They always use the word "an action," and they're using the word "an action" as in a cause of action brought to correct a wrong. Why is this a cause of action brought to correct a wrong? It seems to me this is not a cause of action at all. It is something that relates back to a judgment of divorce, and therefore, if I conclude it's not an action under 5809, I don't see how you get to the benefit of this limitation period.
Well, it relates back to a judgment of divorce that isn't enforceable any longer. So the court really doesn't have the power after that 10 years to grant somebody a quadro.
Well, does that make it an action now?
I think it is. I think well, you're using action as a term of art that I'm not. I think it's an effort to enforce property division that is spelled out in the judgment of divorce. And it's pretty clear that if you don't do that timely, it does result in harm to a party. I mean, in this case, Sherry Dorko has already filed motions in the trial court to get thousands of dollars from Rick Dorko because he received retirement monies that she thinks she should have received because
But wasn't he?
But
wasn't
that
he a
action we can
once-
deal with next time, yeah. Right.
Yeah. I was just going to say, but isn't there a sense of awareness from when the initial result is filed with the court? Like, is this coming as a surprise, or isn't this something that's kind of understood from the final judgment?
Well, I think it's uncertain when you're looking at accrual. If we just say accrual is when somebody receives their benefit, okay? That means that it's an unknown thing. Unless you send an investigator out there and find out when Joe is going to retire, you're not going to know when the accrual happens, so you won't know when your statute of limitations period is, versus the certainty of 10 years from entry of the judgment. And oh, by the way, you can renew that if you choose to, if you're attending to your rights. But none of that was done here, and I think it does harm Rick Dorko, and I think it'll harm other litigants in the state.
Thank you, counsel. The case will be submitted.
Thank you very much.